It's your turn, Mr. Rennie.
Thank you, my lord. My lord, the determination of this appeal depends in our submission upon starting from the correct starting point. There are two alternative starting points. Is the starting point the fact that in law, demurrage has come to be classified as liquidated damages, so that it has to be approached in a certain way and with certain assumptions a priori as to the extent of its coverage and its intended scope? Or is the correct starting point the identification of what demurrage is and is intended to be, so that the label, liquidated damages, which has come to be affixed to the concept, has to be read in the light of and subject to that context of the particular payment which demurrage represents? And in our
Why on earth does that answer the question?
well, because it answers it because you don't start off, as the appellants do, by saying it's a liquidated damages clause, therefore you assume it has a particular scope.
I mean, even if it were a liquidated damages clause, it might be a liquidated damages clause of limited
Absolutely,
scope.
absolutely.
So, I mean, it doesn't, it seems to me that I mean, I would love this case, the answer to this case to be what you say, namely identify the correct starting point, and we've got the answer. But it just isn't. I mean, the starting point here is the meaning of demurrage.
Well, that's precisely what I said as part of the correct second starting point.
Yeah.
You work out what it is first, and then you ask what sort of liquidated damages is it? Because just because it's given the label liquidated damages, which came about rather later in the history of demurrage, doesn't actually tell you what it means.
No.
And there is a risk in this case with the over-elaboration of analysis and microscopic parsing of different cases of losing sight of what we say is the pretty simple position. And I'll take your lordship to the judgment of Lord Justice Diplock in Swiss Atlantique, who found the issue in the case very simple. And we submit it is as simple as he found it for these reasons. Demurrage in its origin and conception from its earliest days to the present has been calculated as a time payment to compensate the owner for not getting his profit-earning chattel back at the end of the lay days. Secondly, that time payment...
Hang on.
Sorry.
Yes.
Secondly, my lord, that time payment is a daily freight rate inspired or based concept and has always been linked to the covering of costs and the loss of the profit-earning capacity of the vessel, estimated as at the end of the lay days.
Surely it depends on what the parties negotiate.
Well, my lord, as we'll see, there is no other form of calculation of demurrage. It's based on a daily rate. It's highly market sensitive because as market rates change for freight, the ship owner is trying to guess ahead what he might lose if the vessel exceeds whatever the lay days are. Thirdly, connected with that second point, it has never been calculated and is not now calculated, assessed or computed on any other basis, and is self-evidently not seeking to reflect or to take it into account any other potential form of different loss. Fourth, the later classification as a matter of law of demurrage, open quotes, close quotes, as liquidated damages that happened in the 1920s tells one nothing about what they liquidate and did not change the fundamental character of what demurrage was and was doing. That really is the liquidated damages label point. Fifth, if one stands back and looks at the cases, the underlying and pervasive theme running through all of them down to the bond, which is a late outlier in the history really, is what is the nature of the loss claim? Is it different from the loss covered by the demurrage payment for loss of use, loss of earnings, time detained? Or is it really just that sort of loss in which case it has been, in Lord Justice Diplock's words, paid for? And my Lord the Master Rolls was right to focus on the fact that different judges use different terms, and one of the matters the court will have to identify is what they mean when they say for detention. Because in our submission, it's quite plain when one looks at the context and the series of cases that what people are talking about for detention is the loss caused by detaining the vessel as a profit-earning chattel. And so we see that in Invicip and Bungi, Ryder and Arcos, Chandris and his Branson Moller, and Swiss Atlantique, especially Mr. Justice Makata, and the Court of Appeal was more or less endorsed by the House of Lords. At sixth, there is no binding authority in this case, either Court of Appeal or House of Lords level. And in our submission, the decision in the bond did not settle anything. Indeed, on one view, it unsettled what had been a long line of cases, Chandris and his Branson Moller, the Malthus, the Adelpha, what the Court of Appeal said in Swiss Atlantique, and came about with a completely new category, which is you can only recover beyond demurrage if you're able to show a second breach and a different loss. And no case had said that before.
They may not have said it before, but certainly in Ryder and Arcos, that they were considering whether there were two breaches or not, at the very least.
Absolutely, my Lord, but part of the problem with considering the authorities is that the focus has shifted to one breach, two breach, rather than what is demurrage. What is this concept? What is it liquidating? And one will see that in Invicip and Bungi, which is a very important case, and in Ryder and Arcos itself. So, my Lord, unless I can take the matters in any different order to assist the court, I propose to structure my oral submissions as follows. First of all, I'm going to deal with the relevant charter party terms, because we are construing a contract.
Amazing, and we haven't looked at it.
We haven't looked at it. It is a slightly, I mean, it's terse, but it's still worth looking at. And comparing and holding up, here I do say compare and contrast, but with the building contract cases on exclusive, on liquidated damages, because they are completely different.
They are. Of course they are.
Of course they are, my Lord, yes. The second is the meaning of the term demurrage in context.
So this is the order you're getting.
This is the order I'm going to go in.
Okay, charter party. Meaning of the term demurrage.
And because your Lordship asked quite an important question, which is what do the courts say demurrage is? And one could come into this appeal thinking, what is this thing called demurrage? It's this nebulous concept. I mean, there are many, many cases which deal with the concept and explain precisely what it is, what it's been calculated for, and why it's there.
They do, however, seem to use some sloppy language.
Yes, but your Lordships will put together the composite picture and see that actually there's one very, very clear theme. Yes, they may say detention here or delay there, but that's the difficulty with micro-parsing.
I meant focusing on what it's for generally rather than what it is always for, so that they don't necessarily focus on precisely because they know what the term means.
Yes.
Anyway, we'll see that when we come to it.
Yes, my Lord. And then, in dealing with the meaning of the term demurrage, I will address why and how the label liquidated damages came to be affixed to it, because that's important.
Well, you know, labels are very unhelpful.
My Lord, that was the judge's view, and that is our view as well.
But I mean, be careful, because you could agree with the judge on that and not agree with him on other things.
Yes. Quite true, Lord. Then I'm going to break down. Then I'm going to break the authorities down into three stages. First of all, the pre-bond authorities, Invicip, Ryder, and Swiss Atlantique. Mm-hmm. Then the bond, and the continuing debate. And lastly, I'll deal with commercial considerations which have been relied upon by the appellants, to say that the result that they want is the right result commercially. So if we can go to the charter party, my Lord, which is in the core bundle at tab 9, page 142. and this can be taken very, very, very briefly because the terms are terse. If one just as it were, hovers over
So
page
did you say 142?
Page 142 of the core bundle, my lord.
Yeah.
Tab 9. And the lordship have it? The lordship should have clauses 18, 19 and 20 on that page.
Yes.
Thank you. So we have here a traditional scheme in shorthand. Laytime, which is the time allowed for payment for the relevant cargo operations comprised within the payment of the freight, and then 19, demurrage. Demurrage at loading or discharging ports, if incurred, that tells you you're incurring something, to be declared by the owners upon vessel nomination at the maximum 20,000 per day, or pro rata. So here you're looking at a time payment, which literally is divided down by the last hour and by the last minute. A laytime statement and a demurrage statement will calculate that down to the last minute because of the pro-ratering. So you're paying, as in one sense, for time. Dispatch, half demurrage, laytime saved at both ends. And one can tell this is a time clause because if one goes on to the last three lines, starting at line 184, one has the words, any time lost, for which charterers and receivers are responsible, which is not accepted under this charter party.
So where did you see?
I'm so sorry, Lord, line 184, still in clause 19. Any time lost.
Yeah.
The last sentence. Any time lost for which charterers and receivers are responsible, which is not accepted under this charter party, shall count as laytime until the same is expired. Thence, time on demurrage. So we're dealing with time concepts, loss of time, prorating time. And in our submission, it is important. We don't say that demurrage clauses are different. They usually are very, very bog standard. They come in a very traditional form, and this is one of them. They may have different bells and whistles. They may have half demurrage exceptions, and so on and so forth. But this is the general scheme. If one turns over, one sees again how this concept of time on demurrage is used. Just look at the bottom of the page, clause 27. There's a water pollution clause, and any time lost, again, on account of non-compliance with government rules, shall not count as laytime or time on demurrage. So time, and then in the next clause, clause 29, strikes, stoppages and delay. This deals with problems affecting loading and discharging of the cargo, so the very operations that need to be carried out in the lay days, where it's affected by riots, civil commotions or strike. And it says that, I won't read it all out, the court will have to read it to itself later, but there are various exceptions to demurrage here. And if one goes to the last sentence, in case of any delay by reason of the before mentioned causes, no claim for damages or demurrage. So the idea that demurrage is a sort of general head of damages which covers everything is not borne out by the language of this particular charter party, which draws a distinction. And those are the contractual terms.
Where's the limitation clauses that were referred to this morning?
Well, if your lordship looks at the next page, page 144, you have about halfway, just after halfway down, clause 35, exceptions, and that is a general exceptions clause. All voyage charter parties have them. The GenCon clause has clause 11, the Aspertank Boy clause has clause 19, and therefore, and I'll come on to this when we're dealing with the commercial aspects, the argument that, well, it's very odd that if there's an exception to demurrage, there won't be an exception to the unliquidated damages for the other loss. It depends on what the event is, but generally speaking, there is a wide general exception which covers all claims due to certain causes.
Claim for demurrage has to be made within 90 days?
Not under this charter party, my lord, I don't think. That's, I think there's no time bar provision in this charter party.
So it's governed by the normal law.
Yep. So you put your claim in, and the very rigorous regime under certain types of time charter party, typically tanker time charter parties, where you have to put in a notice of readiness, statement of laytime, and all supporting documents, or forever lose the claim, doesn't apply to this charter party.
But the 90-day, 6-year distinction that was being made by Mr. Hayward is not applicable here.
No, it isn't.
And it would be in some.
It would be in certain charter parties, yes. And I'll come on to whether that matters when I'm dealing with the commercial considerations. So that's the charter party. Now, my lord, I won't take you to the building cases because they all say the same thing, and they're all more or less considering the same form. But in our submission, one gets no assistance from statements of principle in those cases when one considers the contractual provision which the courts are considering and applying. I give one example, which is Temlock and Errol Properties, taken from the JCT Standard Form 1980, Private Without Quantities, Clause 24, and the JCT form repeats that in different variants of the JCT form. And that talks of a sum as liquidated and ascertained damages for the period between completion date and the date of practical completion. Well, that as a matter of construction raises completely different issues. And so the long series of building cases, 1, 2, 3, 4, 5, 6, 7, I think, on similar wording, liquidated or ascertained damages shall be, don't assist in our submission. So those are the contract terms. I now come on to the concept of demurrage in voyage charter parties, how it is calculated and what it represents. And
is it different in voyage charter parties from elsewhere?
It really is only a voyage charter party context, my lord, a concept, because the voyage charter party consists of a fixed freight to carry from A to B. Within the freight, and there are various permutations, but in general terms...
You have container demurrage, for example.
Yes, you can have the concept of demurrage in container leasing contracts, yes, certainly, my lord. But under the voyage charter party, you have the central freight, which gets you from A to B. You have some time at the beginning and the time at the end, which is allowed in that freight to get your cargo off, or get it on and get it off. Those are the lay days, and then if the lay days are exceeded, you're then on demurrage, time on demurrage, and you pay for that at a rate which is, as we'll see, very heavily freight related.
Very heavily?
Freight related.
Yes.
Giving the owner back what he hasn't got, because he hasn't got his vessel. Mm-hmm. You contracted to give the vessel back after 4 weather working days, whatever the particular laytime provision is. But if you don't give it back, then the owner can't put his vessel straight onto the market and relet it at whatever the rates then are. And he has to make an estimate about what the daily rate that he's going to charge is, and that will be plainly the serious subject to negotiation. You can imagine brokers saying that's far too high. The market will never do that. Or saying, well, take it or leave it, this is a good vessel, and that's how it will go. But no one's ever contemplating when they're negotiating the demurrage rate, but what about wider losses? And our submission, that's a very, very telling factor which the judge took into account. Because the appellants have to say in relation to that, well, that's just the figure they pick. But that's not really looking at demurrage if we're trying to understand what it is, the shorthand word.
But I mean, wider losses are quite unusual, aren't they? I say unusual. I mean, we've struggled to think of examples. We've thought of fouling. We've thought of tornadoes. We've thought of cargo deterioration, as in this case.
Yes.
But and you can take the facts of the cases we've looked at.
Yes.
But these are not everyday occurrences, which is probably why we're 30 years since Mr. Justice Potter decided the bond.
Well, it may be that the actual operation of an unliquidated damages claim for the separate loss doesn't arise very often, because normally there isn't one. And alternatively, that if there is a separate loss, it's obviously been caused by an event which is within the general exceptions clause. So you won't have a claim anyway. Because
or exactly, it's either within the general exceptions, or it's a special and unusual circumstance, and a different breach.
Yes. And so one has either to take that and, as it were, postulate what the reasonable brokers are thinking. Are the reasonable brokers thinking, well, they're pretty unusual, so this will cap every Or are they thinking, well, we don't know whether it doesn't come up very often, they'll have to be dealt with by the other provisions of the charter party. But what we do know will happen is I won't get my vessel back, and I'll be out of the market, and I'll be bearing the running costs of that vessel.
That is why your argument that this is how it's negotiated, which sounds a bit like evidence to me, but nonetheless, is interesting but not conclusive.
No, certainly not, my lord.
No, because you would do that because that is the main event. That's what you're normally talking about.
Yes.
And the rest of it is a risk.
It is a risk.
Yeah.
The bottom fouling is not, well, it's neither unusual nor unforeseeable. On the contrary, if it's in the right part, the wrong part of the world, and the delay is long enough, it's simply going to happen.
Yes.
But that doesn't seem to have been a problem under the bond for the last 30 years.
Well, it doesn't seem to be, my lord, no. And it may be that, I mean, it depends whether bottom fouling is regarded as an ordinary cost. So if you go to a port which has lots and lots of marine growth, and you're going to be there for 5 days, lay days, and you know she's going to be on demurrage after that, or at least she may be if she doesn't discharge, there will be a bottom fouling cost. Now, if she stays there for a year, which is slightly unrealistic on demurrage because there'll probably be a repudiatory breach of the charter party. But, so, in our submission, the erection of these, how do we draw the dividing line? It is slightly artificial.
So just so I'm clear, so bottom fouling can be expected in certain places.
Yes.
That will therefore be taken into account in fixing the demurrage rate?
Well, I'm not a broker. So
You're not a broker, but you would expect it to be taken into account.
You would, my lord. I mean, you'd expect an intelligent broker to say, we're sending into these waters where everybody knows growth starts almost straight away.
Yeah. And therefore, as a matter of principle, there should be no extra claim for bottom fouling.
Yes, you would. The argument the other way would be, well, ordinary operating costs, extra bunkers, fuel oil, port costs. Instead of being there for 5 days, you're there for 10. The port costs are going to be more. Those are all covered. Bottom fouling. Well, bottom fouling, it's slightly worse after 10 days than it will be after 5. Well, that's covered by your demurrage.
But why?
Well, no,
I mean, where does it? How do you know bottom fouling is covered and port costs are not?
One would need to look at the particular facts of every case, but the argument that, well, because you have to distinguish between different types of loss, therefore the judge must be wrong, doesn't account for the decision of the Court of Appeal in Inverkip and Bungie, which said that the loss has to be not one which is covered by demurrage as a detention loss.
Can I just pick up one point? Was the idea there that port costs would not be covered by demurrage?
No,
I thought you were saying they would be covered.
I would have thought port costs would be. Yes.
Yeah.
Certainly. So, my lord, I was going to take you to some snapshots of the relevant history of demurrage, and to see whether it has really ever changed. I've set out in our skeleton argument references to Abbott on merchant shipping 1802 and laws on charter party.
I don't have a copy in my room. Do I need one?
No, my lord, your lordship doesn't. And you can't have the Middle Temple's copy of laws on charter party 1813 because I had to be under armed guard when I was allowed to touch it. But what they say, if one just looks...
Can we look at them?
Yes, my lord, shall we? Abbott is at tab 2, sorry, bundle 2, tab 39, page 568.
I should regard this as a privilege, even if it's on my screen.
No, not this one, my lord, but the next one. The next one, definitely.
I must say it looks old, even on my screen.
1802, my lord.
Sorry, what tab did you say, Mr. Rainey?
Tab 39, at page
Thank you.
568.
565.
And it's the second part, which says, right at the bottom of the page, frequently, also, it is stipulated that the ship shall, if required, wait a further time to load and unload, or to sail with convoy, we're in the Napoleonic Wars at this time, for which the merchant covenants to pay a daily sum. This delay and the payment to be made for it are both called demurrage. And then if one goes on in time, not very far, to laws on charter parties at tab 50, this is the one which is the privilege to look at.
Tab 50.
Tab 50, my lord, page 683.
Mr. Edward Laws of the Inner Temple.
Yes. This never went to a second edition, I don't think.
Perhaps he took silk and was too busy.
So at the bottom of page 683, my lord, demurrage may be defined, the compensation to be paid by the
Sorry,
freighter.
we're reading.
I'm sorry,
I
at the
see,
bottom of
demurrage
page
may be
683.
defined, yes. Compensation to be paid.
By the freighter to the owner or master of the ship in case she is detained beyond her lay days, viz. Those allowed by the contract for her laying to load and unload the cargo, or if no particular time be limited by either of them for that purpose, in case the ship be detained beyond a reasonable time. And then these words, in general, a certain rate of compensation is provided by the charter party for the ship's detention for a fixed number of days after the expiration of her lay days, which extra days are called days of demurrage. Any additional number of days which the ship may be detained beyond the expiration of that period come under the same denomination, for both the owner and master of the ship has a right to compensation from the freighter or merchant if, as it usually happens, he causes the delay. The only difference is that the compensation for the stated number of days is generally, though not necessarily, limited by the charter party, so that it is known what is to be paid for that time. Now, at this stage, demurrage was, generally speaking, a fixed period, which is why Edward Laws writes about days on demurrage, and which explains Lord Trainor's statement in Lilly and Stevenson that days on demurrage are just lay days which have to be paid for. I'll come back to that in just a moment.
But your point about this is that it's what's to be paid for the time.
Yes, and if we jump forward in time to the Brontados decision, which the court will find in Bundle 1, tab 15, the decision of Mr. Justice Donaldson. Mr. Justice Donaldson with enormous experience in this field. And
Sorry, which tab did you say?
so sorry, tab 15.
15.
15, 1-5.
Sorry.
Yes, the Navico and Brontados decision. And we start at the top of column 1, where Mr. Justice Donaldson said there's no magic in a charter party. And then he says, accordingly, I approach the construction of this charter party, bearing in mind the general nature of the commercial bargain which is contained in voyage charter parties. Now, contracts for carriage of goods in consideration of the payment of freight. The freight covers the passage between the loading and discharging ports and an agreed conventional period of time for loading and discharging the cargo, the laytime. I say conventional because although this period may have some relation to the time which the parties may expect to be spent in loading and discharging, no one will be more surprised than they if this estimate prove completely correct in the event. Almost all charter parties go on to make provision for adjustment in the payment due from or to the charterers according to whether the processes of loading and discharging take more or less than the laytime. All the overhead and a large proportion of the running costs of a ship are incurred even if the ship is in port. Accordingly, the shipowner faces serious losses if the processes take longer than he had bargained for, and the earning of freight on the ship's next engagement is postponed. By way of agreed compensation for these losses, and I emphasise these, the charterer usually contracts to make further payments, called demurrage, at a daily rate in respect of the detention beyond the laytime. That's a helpful guide to what detention means. If the processes of loading and discharging take less than the conventional period, the shipowner in theory at least reaps the advantage of being able to proceed earlier upon the ship's next freight earning engagement. I stress that. In recognition of this advantage, provision is usually made for the payment by the owners of a rebate of freight at a daily rate for all time saved. This rebate is known as dispatch money, dispatch rebate, or more simply dispatch, since the ship owner may have difficulty in obtaining another engagement at short notice or advancing the date of the ship's next voyage. He stands to gain less by unexpected expedition in loading and discharging than he stands to lose by delay. Accordingly, dispatch is usually payable at half the demurrage rate. So one sees, and those are the provisions which we've seen in the charter party, which I took you to. So that is the scheme. And then if we turn on in this bundle, please, to tab 17.
But you're emphasising, are you, the words taking longer and earning of freight?
Yes.
As
And
being
also
the material things
yes.
that it's about.
Absolutely, my lord. And the words used by Mr. Justice Donaldson, by way of agreed compensation for these losses.
Well, those are the losses.
Yes, those are the two
I've
losses.
gone back to the two losses
Sorry, Lord, yes.
that he was referring back to.
Sorry, my lord, yes.
Yeah.
And that, as soon as that decision was reported, in the next edition of Scrutton on Charter Parties, and it's been there ever since, the decision was referred to in a footnote as explaining the commercial scheme of demurrage. So if I can ask you, if you can keep bundle 1 handy, those are working in hard copy bundles, can I ask you to turn to bundle 2 and tab 59, which is the 24th edition.
Well, that's the 2019.
Yes, I'm looking for the edition.
You obviously want the
1974, madam.
24.
Yes, it's tab 58. I'm sorry, I couldn't read my own writing. And if your lordship turns in that, please, to page in the bundle. I can't see my bundle reference page numbers because they've been printed in black. But it's page 303 of the book, and it's headed section 14, demurrage.
Yeah.
And at footnote 2, we see the editors of that edition saying, see Navico and Brontados for a discussion of the commercial basis of demurrage. And so that is what people in the industry, both legal and practical, will understand.
Sorry, I just can't see where that is.
I'm so sorry, my lord. It's page 303 of the book.
Oh, I'm sorry.
And it's footnote 2. And where they're dealing with liquidated damages for delay beyond a stipulated or reasonable time for loading. And they say at footnote 2, see Navico and Brontados for a discussion of the commercial basis of demurrage.
Unfortunately, I don't seem to have that page. I have 306, 307, 308.
746 of the electronic bundle, my lord, if that helps.
It's much further on, 746, thank you. That's page 311. Which number footnote?
Footnote 2, my lord. See Navico and Brontados for a discussion of the commercial basis of demurrage.
No, I'll just note it down. It's not
I
at
apologise,
those
Lord.
pages, I'm afraid. It's you say it's at page 302 in Scrutton.
303 of the 18th edition at footnote 2.
Although it goes on to refer to note 2 on page 305 of the book,
Yes, my lord.
which says the provisions as to demurrage quantify the whole of the damages arising from the charterer's breach of the contract in delaying the ship.
This was the period when there was a revisionist view in Scrutton, as traced by the judge through the exhaustive history of what Scrutton was saying. What I'm doing at the moment is looking at what people understand by demurrage and what demurrage is and how it's calculated.
And I see that, but seemingly the editors of Scrutton didn't see an inconsistency.
I see that, my lord, yes. My lord, can we go back to the authorities, and can I take you to Diaz and Louis Dreyfus, which is in bundle 1, tab 17. This is in the speech of Lord Diplock, giving the...
Sorry, I must be in the wrong place.
Tab 17 is
Tab
the
17,
LTIS,
Lord.
tab 16 is the DS.
Oh, I see.
That explains it, my tabs are right. So
Which page in DS?
in the DS, my lord, it's at page 229. Of the bundle,
Mm-hmm.
263 of the report, and your lordship sees the bottom H. If laytime ends before the charterer has completed the discharging operation, he breaks his contract. The breach is a continuing one. It goes on until discharge is completed and the ship is once more available to the ship owner to use for other voyages. But unless the delay in what is often then incorrectly called redelivery of the ship to the ship owner is so prolonged as to amount to frustration of the adventure, the breach by the charter sounds in damages only. The charter remains entitled to continue to complete the discharge of the cargo while remaining liable in damages for the loss sustained by the ship owner during the period for which he is being wrongfully deprived of the opportunity of making profitable use of his ship. It is the almost invariable practice nowadays for these damages to be fixed by the charter party at a liquidated sum per day and pro rata for part of the day, demurrage, which accrues throughout the period of time for which the breach continues. And then, my lord, if I can ask you to turn on to...
So what do you get out of that?
My lord, what I get out of it is that it's dealing with the loss sustained by the ship owner during the period for which he's wrongfully deprived of the opportunity of making profitable use of his ship, and that those damages are fixed at the liquidated rate.
Loss sustained during the period. So the way he puts it is at odds with what we were looking at before. I mean, that's ambiguous as to whether it's all the loss sustained during the period.
Well,
but it is different, isn't it?
well, my lord, we would say not, because it goes on to say it's not during the period when the vessel is detained. It's during the period for which he is being wrongfully deprived of the opportunity of making profitable use of his ship. So he's referring to a particular type of loss which the ship owner will incur during that period.
Well, I think you see my point.
And that passage was endorsed in the lips at tab 21. We were taken to this morning by Mr. Hancock, and it's at page 299 of the bundle.
$299.
$299, my lord. And you were taken to passage in the speech of Lord Brandon at E about it being liquidated damages. But if you read on, you will see that Lord Brandon went on to say these propositions of law are so well established, the citation of authority for them is unnecessary. See Ryder and Arcos and the Diaz case, where the very passage which I cited from Lord Diplock is then set out in extenso by Lord Brandon.
And Ryder and Arcos is relied on for the fact that it's breach, is it?
Yes, my lord, because Ryder and Arcos was one of the cases that got rid of the idea, Lord Rayner,
that it wasn't breach.
that it wasn't breached, that it was days on demurrage or
Yep.
days being paid for. Yes, absolutely, my lord. So that's why he's referring to Ryder and Arcos there. And then, if we then go on to the textbooks, if I can ask you to take up bundle 2 of the authorities bundle and turn in it please to tab 60.
Sorry, I missed your reference.
So sorry, bundle 2 of the authorities, tab 60.
Thanks.
is John Schofield's book on laytime and demurrage, which is a standard in the Line Shipping Law Library. Its first edition was 1986, I think. And if you turn
This is 2016.
This is the 7th edition of 2016. If you turn over to page 789, so this is John Schofield is a LMA arbitrator of very long standing, very busy in the LMA world, and he wrote this book in 1986. It's gone through successive editions. And this is what he says at the top of page 789 about demurrage. Paragraph 133, so this is an introductory section, if you like. If loading
paragraph 133 I don't have on
so
page 789.
1.33, top of page 789.
No.
I'm hoping that the numbers in my hard copy bundle are
Right, that's on page 781, 133. Okay, keep going. If loading or discharging.
If loading or discharging are not completed within the time allowed, then the ship owner is entitled to be compensated for the extra time taken. This may take the form of liquidated damages, demurrage, or unliquidated damages, where the claim is one for detention. Demurrage is usually specified in the charter as a daily rate, and the parties may either agree for a limited period on demurrage, or more commonly, for an unlimited period. The demurrage rate fixed by the it is now generally accepted that failure by the charterer within the time allowed is a breach of contract. In the next paragraph, the demurrage rate fixed by the parties is intended to cover the vessel's daily running costs, plus the profit the ship owner would have been able to earn had his vessel been released timiously. There are, however, some charter parties where demurrage is rarely earned, and then it deals with what's called dispatch business. So when the court was asking earlier, what do people understand demurrage is doing, one has clear statements in the cases, and one also has clear statements in the standard text.
Just to be clear, when he says take the form of liquidated damages, demurrage, or in unliquidated damages, he's not postulating three things. He's postulating demurrage as liquidated damages.
That's my reading of it, my lord, yes, because this should be liquidated damages, comma, demurrage, comma,
Yep.
should be, or unliquidated damages.
Yeah.
And then, lastly, on this, my lord, reflected in the fact that a claim, if a claim for detention outside the demurrage period is made, the rate taken is usually the demurrage rate, because it represents the best indicator of what the profit-earning capacity of the vessel was as damages for detention. And one sees that in the textbooks. If I can ask you to look at Carver on charter parties in this second bundle of authorities at tab 44. And the page in the hard copy bundle is 614. In case I know the master rolls that doesn't work, in the book it's at page 1357. And it's at paragraph 12-204.
And this is the original edition before the editor's views were contaminated by the decision below.
This is the original, this is the first edition, yes. Lord, yes, that's right. And what it says at paragraph 12-204 is this: in situations which fall outside the scope of the laytime provisions of the charter party, damage will be assessed at the market rate for the period of detention, again the use of the word detention there, which provides the best guide to the earning capacity of the vessel. In this context, the demurrage rate will usually be prima facie evidence of the market rate, but it may be displaced by more accurate contemporaneous evidence of the market rate of the vessel, which may be adduced by the ship owner or the charterer. And interestingly, I won't, because of time, take you to it, but in the extract from Carver on Carriage of Goods, first edition 1885, precisely the same statement is made. That for the court's reference, is bundle 2 of the authorities, tab 43, page 593. And so, in our submission, there really cannot be very much doubt as to what, if you look at a charter party and it says demurrage, what demurrage means and what it connotes and would convey to the reasonable maritime contractor.
It doesn't really answer your question there, does it? It doesn't answer the question. It simply sets the scene for the question.
Well, my lord, the question is, what does demurrage mean?
No, and I understand that. It tells you what demurrage is for.
Yes.
What it does not tell you is whether it is exclusive or not.
Well, my lord, it doesn't. But in all the statements we've looked at so far, there is no suggestion that it is intended to cover anything else.
Well, to the contrary. I mean, DS, which you say is very important, on one analysis, not the one you choose, but the one that, the way I read it, it says the loss sustained during the period he has been deprived of the profitable use of his ship. And that is not directed at the fact that he's been deprived of the profitable use of his ship, but the loss sustained during the period, in other words, all the loss.
Well, in which case, my lord, all that needed to have been said was the loss sustained during the period until loading or discharging is completed. But
well, you could say that, but he didn't. I mean, that's the whole trouble with these definitions. They're not, I mean, one hesitates to say drafted by lawyers, but not with the relevant, the question we've got in mind,
yes,
which is why they're not conclusive.
I'm not saying that any particular passage I've cited is conclusive.
No.
Your Lordship has to put together the pieces and see what is the common theme, if there is one. Is the common theme that demurrage is intended to cover all losses, or is the common theme that you're trying to work out a calculated rate to cover what you can't get on the market and what you've got to pay in costs which are not met by freight? And in our submission, what comes out of what I've cited is all in one way. What then happens is the characterization of demurrage as liquidated damages. And as we've seen, there were two competing analyses. Going on to demurrage was effectively extra laytime, which the charter was entitled to use by paying a day rate for it. Lord Trainor's analysis in Lillian Stevenson. Or the alternative analysis that going on to demurrage was a breach of laytime, and therefore the owner's loss of use of the vessel was to be paid for by way of demurrage as liquidated damages for the loss of time. And in our submission, we'll see this coming up in the cases which I'm just about to come on to. But nothing changes in relation to what demurrage is and how it's calculated and what it's doing, simply because in Invicate and Bungie and Ryder and Arcos, it's called liquidated damages rather than a daily payment which would be recoverable in debt. And so statements looking at cases which say demurrage is liquidated damages really take one nowhere, because you have to ask what the concept was, what the concept is. Did the concept change when legally it was reanalyzed as being liquidated damages? And the dictum of Lord Rayner in Lillian Stevenson was discarded. And so in our submission, if one looks at what the judge said about this, just to summarise before we come on to the cases, first of all, at paragraph 61 of the judgment, where the judge has summarised the various commercial materials, some of them which I've been taking the court to. In paragraph 61, the judge says, agreeing a demurrage rate gives an agreed quantification of the owner's loss of use of the ship to earn freight by further employment in respect of delay to the ship after the expiry of laytime, nothing more. Where such delay occurs, the demurrage rate provides an agreed measure by which the parties are bound for the owner's claim for damages for detention, but it does not seek to measure or therefore touch any claim for different kinds of loss whatever the basis for any such claim. And our submission, that is a correct finding of what demurrage is and how it is understood. I now come on to the cases, and as I said, I will deal with them in a number of stages. First of all, I will deal with the pre-bond authorities and the cases as they proceed down to Swiss Atlantique. And in considering the cases, the court needs to focus on what the relevant question in our submission is. What is the court looking for in the cases? My Lord the Master Earl said this morning, well, what people understand by demurrage. And we agree with that, and I'll come on to some statements which we say are important in all of the cases. Do the cases suggest that where there is a breach of the laytime provision, if there are two types of loss, one loss of use, one a different head of loss, that head of loss is not recoverable? And part of the difficulty with the cases is that one's picking around trying to find things which say, oh, if it's only one breach, laytime provisions, then you can't get any loss except demurrage because the different head of loss is wrapped up in the demurrage payment. And so that's what we're looking to see, whether that proposition is supported or gainsaid by the cases we are looking at, and how the court describes the purpose and function of demurrage. And what we're also looking for is there an emphasis by the court, in any of the cases we're looking at, one breach or two breach, on what the nature or type of loss was? Because in one sense, if type of loss doesn't matter, then if anybody is putting their case simply for breach of the laytime provisions, the court doesn't need to go there. And then one has the oddity, as we'll see in Invicip and Bungie, that where you do claim a separate breach on top of the breach of laytime, demurrage will liquidate the loss if the loss sustained as a result of the second breach is loss of use, which causes the owner no more than extra costs and loss of freight. And one of the aspects which hasn't been touched on by the appellants, but which the judge found significant, was how do you square this scheme? If demurrage is liquidating damages for loss of use and loss of freight earning in the period, why is it doing that only in the context of a separate breach, but doing much, much more in the context of the breach of the laytime provision? And that's where the judge set out, I think, in his judgment, his little grid.
What's the reference? Oh, it's his grid, yes.
Yeah.
I found that a bit difficult. Was that just me?
I think it's easier just to say it in sentences, my lord, yes.
Yeah. Well, maybe just I'm a sort of words person.
Yes. So, my lord, can I start with Invicip and Bungie, which is in the authorities bundle at tab, first authorities bundle at tab 4. And I'll take this as quickly as I can. You'll see from the headnote that this was what was then relatively modern, open-ended demurrage provision. So no fixed time on demurrage. It was just after 5 days on demurrage. And then you'll see also in the headnote, dictum of Lord Trainer and Lillian Stevenson disapproved. So we will look at that. And the argument was put, and the difficulty with looking at demurrage as being lay days which are paid for, was that works if the period is fixed, because then you go on to unliquidated damages for the same loss. But if demurrage days are unlimited, when can you get unliquidated damages, if at all? And so what the argument was, and you see at page 22 of the report, Mr. Wright, the appellants, the argument was, oh well, in which case demurrage comes to an end after a reasonable time.
And after that, you've got unliquidated.
and then you got unliquidated damages. And that was rejected by the court. The other argument that Mr. Wright advanced, which you see on page 23, is that there were two breaches. So he said that detention for an extraneous purpose is not within the agreed rate of damage, and the detention, as we see at the bottom of the paragraph, the detention there as here was not due to delay in loading, but to not having a cargo ready for loading. So the point was being put that there's a difference between being slow and a difference in not having any cargo at all. And what Lord Justice Scrutton said at page 27, again of the bundle, was as follows. The sum agreed, bottom paragraph, the sum agreed for freight in a charter covers the use of the ship and agreed time for loading or discharging, known as the lay days, and for the voyage. But there is almost invariably a term in the agreement providing for an additional payment, known as demurrage, for detention. And what do we mean by detention? Our submission just detaining the vessel.
So I've got a page problem. What's the page in the report?
Page 200, my lord.
Thank you.
I'll give the report numbers as well from now on.
Yes, I've got it.
So he says, but there is almost invariably a term in the agreement providing for additional payment, known as demurrage, for detention beyond the agreed lay days. This is sometimes treated as agreed damages for detaining the ship, sometimes as an agreed payment for extra lay days. In my view, the mere fact that the charter has not loaded the ship in the lay days does not entitle the ship owner to withdraw the ship from the service, and whether the payment for these days after the lay days on which the ship is detained is treated as agreed liquidated damages, or as an agreed payment for time which the charter has a right to use at his option, the amount to be paid for these days is fixed by the charter. So he deals with the argument reasonable time for what? In our submission, that's important because Lord Justice Scrutton, again with enormous experience and probably very familiar with Lilly and Stevenson, doesn't really see a difference between whether it's liquidated damages or agreed damages or extra payment. It doesn't alter the fact that the amount to be paid for these days, and indeed it's not just these days, down to the last minute, which is per day or pro rata, is fixed by the charter. And if we go on to page 30 in the bundle, arguably, and page 203 of the report, he deals with the separate breach point, and he says this: if there was a breach, it's the second paragraph, if there was a breach in not having the cargo ready on August the 25th, the only consequence is detention of the ship, and the damages for that, which is the same detention, however it arises, are agreed in the charter and have been paid. So in our submission again, what the court is looking at in Invacip and Bungi is the fact that when you agree a demurrage rate, you are paying, by way of damages, but you are paying for the extra time which you will take. And why? Because for the extra time which you will take, the ship owner is out of his ship and can't earn profit with it. And then, as you see underneath that paragraph, Lord Trainer's dictum is not approved by Lord Justice Scrutton. So that's when liquidated damages analysis first comes in as a firm principle. And in our submission, Invacip and Bungi is important because it shows that demurrage is the payment to be made for the detention of the vessel, and by that he means any loss of use to the owner by it not having been handed back after the lay days. And in our submission, it is difficult to read demurrage as therefore doing something different when the breach is the lay day, breach of the lay days provision, and yet from what it's doing when it's applying in the case of a separate breach where you're still claiming loss of use. Plainly, Lord Justice Scrutton, he goes to what demurrage is, and he says, look, the loss you're claiming, I don't care what breach you're putting it as, the loss you're claiming is loss of use, loss of time. putting the owner out of his freight. That loss is paid for. And so you can't repackage your case as one for a different breach to get the loss of, to get out of the demurrage provision. That is invocip and bungie, and our submission, the importance of that case, which the judge rightly recognised, should not be overstated, because in any scheme of the appellant's case, invocip and bungie has to be made sense of. And what concept is Lord Justice Scrutton taking and applying? It is only a concept that is dealing with the detention loss, as he puts it, namely keeping the vessel too long and the loss of use and loss of
But it doesn't, I mean, of course, I mean, you're right, it's an argument, but it doesn't answer the question again, because, of course, it covers loss of use. It doesn't tell you it doesn't cover something else. So it tells you the common understanding of what it's there for, but not the innermost consequences of the concept of it being a liquidated sum. So it's, I mean, I understand why you refer to it, but I can't see it as conclusive.
No, well, again,
None of it is conclusive.
Well, I don't say none of it's conclusive, but there comes a stage when one puts enough of these statements together to say, well, what is it that this concept is? I mean, Lord Justice Scrutton isn't saying, well, demurrage is liquidation of all loss suffering from laytime. That includes loss of hire, loss of freight, and therefore it includes this loss.
But he's not saying that because he wasn't thinking about that. I mean, I'm not saying he's not saying it because he wasn't thinking about it, but he's not saying it and he was not thinking about it.
Well, my Lord, yes, but one might ask rhetorically, why wasn't he thinking about it? Because demurrage had a set.
Because this little knotty question was not raised at that stage. I mean, it is a knotty question because it is understood, isn't it, in these cases when they actually move away from the debt analysis to the liquidated damages analysis.
Yes.
It may be there is a consequence of that because, well, I mean, it may be that it's, as you say, it makes no difference, but I'd have to think about that.
Yeah, well, my Lord, it could, hypothetically and theoretically, it could make a difference.
Yes.
It could say, well, people have regarded it as this. It isn't this, it's that, liquidated damages, and that carries with it certain inevitable consequences. But if the way in which the concept was applied before when it wasn't liquidated damages is the same as it's applied after liquidated damages, with people putting their heads together to work out the same rate to compensate a particular loss, then it would be a very odd result, because no one suspected it until the bond. It would be a very odd result for that to have occurred, because as we'll see now with Ryder and Arcos, and the battle with Ryder and Arcos, and this court will have the dubious pleasure of trying to resolve what was the ratio decidendi of Lord Justice Atkins' speech, which we say is clear, but
that wasn't, I may say so, your most persuasive submission.
Well, my Lord, it's because it's become bedeviled by over-analysis, but when one actually looks at what he was saying and how it was analysed,
say that again.
It was much, much clearer. So, my Lord, if we go to Ryder and Arcos,
right.
I won't take you to the judgment of Mr. Justice Greer because I don't think I have time, but let's start at the Court of Appeal, which is in tab 6.
I do notice that, to my slight disappointment, because I looked carefully, that this was a reserved judgment. These were reserved judgments. I don't think they talked to each other when they wrote their judgments.
In Swiss Atlantique, Lord Justice Diplock commented on that very fact, that it read like an extempore judgment.
Yeah, exactly.
Yes.
That's why I went back to look. And it was a month later or something. So
That's right, my Lord, yes.
Yeah.
So, if one looks at, it's not even the summer holidays because it's June and July, but if one looks at the argument,
Maybe they were waiting for the summer holidays.
if one looks at the argument, which is at page 38 in the bundle, page 355 in the report,
Yes.
Mr. LeCain, KC, trotted out again, if I can put it in that way, the Lillian Stevenson Lord Trainer dictum, agreed payment for the use of the ship beyond the lay days, and then dealt with it on the alternative basis that if it was liquidated damages. And as you can see from the argument of Mr. Miller and Sir Robert Aske, it was put plainly on the case that there were two breaches. If one looks at Lord Justice Banks's judgment, and again we're looking now on what people understand demurrage is, and subject to the caveat that my Lord the Master Rolls has put to me about not tackling the other point head on, but again one sees what they're saying. At page 360, Lord Justice Banks says, in the 10 lines down in the main paragraph starting, the ship owner is not entitled, merely because the lay days have expired and the contract is not completed, to treat the contract at an end and to withdraw his ship. It is for this reason, I think, that the stipulation for a demurrage rate is so often inserted in the contract, in order that if the vessel has to remain so as to enable the charterer to complete his obligation, either of loading or discharging, the parties may know what sum will have to be paid for the detention. And then, if we go on to page 45 in the bundle, 362 in the report.
352.
362, my lord, sorry.
Yeah.
Lord Justice Banks says this, and again, this is the type of loss issue coming up fair and square. The only question which remains for decision is the question of damages. If the plaintiff's claim was in substance, though not in form, a claim for detention of the vessel. So these are damages for detaining me. I can't use it. The special damage here claimed for would not be recoverable in Vikip and Bungi, and that links the two cases together. And upon the special facts of this case, the plaintiff's claim appears to me to be, both in substance and form, essentially distinct from any claim from the detention of the vessel. So that is why he thinks that the claim can succeed, because it's not within the remit or the ambit of the demurrage provision. Dropping down to the last paragraph, which my Lord Justice Newey raised with Mr. Hancock, which in our submission is important. This is Lord Justice Banks sitting with Lord Justice Atkin and Lord Justice Sargent saying a pretty important statement about whether demurrage is exclusive or not. He says this: at one time I was inclined to think that where parties had agreed a demurrage rate, the contract should be construed as one fixing the rate for damages for any breach of the obligation to load or discharge in a given time. On further consideration, I do not think this view is sound. I can find no authority on the point, and it is noticeable that in Saxon Ship and Union Steamship it was not suggested that the claim for demurrage excluded the additional claim for special damage arising from the detention of the vessel. So he's a one breach man if it matters. In our submission it doesn't matter, because what he's saying is demurrage covers a certain thing.
But it does matter. It does matter, doesn't it? Because he's looking at the second breach that the others found to be separate and distinct, and actually is conceptually distinct, because it doesn't matter how long you take to load the vessel. If you don't load the vessel full, then there's a loss to the owner in terms of freight, and that is that he is looking at that wrongly as a part of the timing breach.
Well, the breach he's holding is breach of the laytime.
Yes.
Only. So he's not interested in complete.
I know he goes on to say that, but he's not in the majority at all. This is not what.
Well, we need to separate out the
obiter dictum of a dissenting judgment.
We need to distinguish different strands in what people are deciding. One, what is the obligation? Is there one or is there two? Two, what is the scope of demurrage? Does it cover detention losses or other losses as well? And that I think is why Ryder and Arcos has become a little bit bedeviled, because people are not keeping those questions separate. which is why in our submission Lord Justice Atkin is plainly a one breach man, because he may define the breach, and this is why your Lordship said that they don't seem to have compared their notes before they handed down their judgments. But Lord Justice Banks is proceeding upon one breach. You haven't loaded in the laytime.
Well, that's clear.
That's clear. And for that, he says, demurrage is not an exclusive remedy, and you can get damages for not having loaded in the laytime, which are a wholly different loss. That's clear. And he links that very closely to invocip and boogie. So at the moment, we have one breach, and demurrage not an exclusive remedy, but only covering the loss of use or the loss of hire.
Okay.
Now we go on to Lord Justice Atkin. And the question here is he dealing with one breach or two breaches? And if so, what is his definition of the breach? And in our submission, one needs to read this carefully, because we start at page 46 in the bundle, page 363 in the report. And he asked the question whether the loss falls upon the charterer in addition to the demurrage. In my opinion, our decision should be for the shipowner. The result of the authorities appears to be that in a contract fixing a number of lay days and providing for days at demurrage thereafter, so pause there, that's any contract which has a laytime and demurrage provision. The charter enters into a binding obligation, singular, to load a complete cargo within the lay days, subject to any default or the operation of any exceptions, matters which do not arise in this case. Now, is he talking about two obligations there, or one? In our submission, it's one, and what he's done is, whether it's right or not doesn't matter, for my purposes. What he's done is he's viewed it as a composite obligation. You have to load the complete cargo within the lay days, not just any old cargo, the complete cargo.
Well, he says that.
And then he goes on to say, if the lay days expire without a full cargo having been loaded, the charterer has broken his contract. So again, composite of the days having expired without the full cargo having been loaded. And then he says the provisions as to demurrage quantify the damages, not for the complete breach, singular, but only such damages as arise from the detention of the vessel. And again, in our submission, what he's saying is, there's a single breach here. I've analysed what the A binding obligation is, singular, and the provisions as to demurrage quantify the damages not for the complete breach, but only such damages as arise from the detention of the vessel. Absolutely nothing there between Lord Justice Atkin and Lord Justice Banks.
But he was talking seemingly about a breach of his composite obligation, which in reality has two limbs to it.
Yes, my Lord, but what we're trying to get at is whether the Court of Appeal thought that demurrage was an exhaustive remedy or confined only to the such damages as arise from the detention of the vessel. And so that is why people have analysed it. Is he a two breach man or a one breach man? Because if he's a one breach man, then he may have got a slightly different obligation to that by Lord Justice Banks. But what he's saying is demurrage for this single breach is not damages for the complete breach, but only damages as arise from the detention of the vessel.
Yeah, but he's confused. Because if he thinks it's one breach, he's confused. Because you can't have it both ways. You can't have everybody's understanding of demurrage simply being detention of the vessel, delay, failing to load, failing to unload, whatever. And then say, well, it's a composite breach and you can have damages outside the demurrage. Because whether it's composite or two breaches or 1.5 breaches, doesn't matter. You're actually compensating them for something else, which is the failure to load a full cargo.
Yes,
that's the proper analysis, plainly.
Yes, but it's the proper analysis because it's a different loss which isn't covered by demurrage.
Well, yes, but since he didn't understand what he was compensating them for at all, it's hardly very good authority for the proposition you want to get out of it.
Well, my Lord, I think that with all due respect...
it seems to me, now, I'm just looking at this case, Banks didn't understand the case because he thought he thought it was a delay case, and it wasn't. It was about full cargoes. I was going to say this guy, but that's really Lord Justice Atkin. Lord Justice Atkin was confused as to what he was doing with.
But what he wasn't confused, what neither of them were confused about, was what demurrage did.
Well, I mean, I quite agree that in their own both confused ways, they did think that demurrage was not exclusive.
And they built on that because of Indicate and Bungie, which had applied detention and demurrage as a concept that applied to any
The problem
breach.
is, you can see how the argument went, and you can see how their minds varied. So instead of allowing themselves to define a breach of contract by finding out what the breach was and what the loss claimed was, and then making an analysis that some of us were taught when we first went to law school, they got themselves all in a twist about it because neither of these two anyway properly analysed it. Now when we come to Sargent, I think we see something different.
Well, sorry, before I leave Lord Justice Atkin, if we go on
Well, in that case, if you are going on, I'll just ask this. I mean, you can see that he didn't think demurrage was full compensation for failure to load a full cargo. I mean, that's inherent in what he said. The obligation is to load a complete cargo, and if the lay days expire without a full cargo. So he is talking about whether demurrage is compensation for failing to load a full cargo.
yes, where the only reason you haven't loaded the full cargo is because you haven't done it within the lay days.
Yeah.
And he goes on to say, for correlative to the ship's right to receive the agreed damages is the charter's right to detain the ship for the purpose of enabling him, if possible, to perform his broken contract and so mitigate any further damage. So again, linking demurrage to a right to detain the ship. If, however, for reasons other than the ship owner's default, the charter becomes unable to do that which he contracted to do, namely put a full and complete cargo on board during the fixed lay days, and again, that is the single obligation. The breach, single breach, is never repaired, the damages are not completely mitigated, and the ship owner may recover the loss that he has incurred in addition to his liquidated demurrage or his unliquidated damages for detention. And so what Lord Justice Atkin is plainly contemplating there is that demurrage is the liquidation of the damages for detention and nothing else.
Well, it would be if it weren't so confused, because if you talk about the full and put a full and complete cargo, that is not anything to do with the obligation for which demurrage is liquidated damages.
Well, I would respectfully disagree, because what Lord Justice Atkin is doing, I have to move on because I've got other areas to go to.
We're just having the fun that everybody else has had with this case.
I'm enjoying to mention it.
Yes.
But what he's saying, he views the lay day. I mean, if you go back, a contract fixing a number of lay days and providing for days of demurrage thereafter, the charter enters into a binding obligation. So he's looking at this as a laytime and demurrage situation.
Anyway, I mean, I get the point.
And we come on to Lord Justice Sargent. Yes, he analysed it as two separate breaches. But in our submission at page 49 of the hard copy bundle and 366 of the report, he's looking at it as being a separate and different loss. But why? If it's enough to say, oh, if you sue for a second breach, then you're not within the demurrage, because demurrage only covers laytime. I'm suing for a completely separate breach. Well, we know that doesn't work, because that's what Mr. Wright tried in Invocate and Bungie. And if you trot up with a second breach and say I can avoid the demurrage clause, you can't if the loss is the same as covered by the demurrage clause. And that's the point being made by Lord Justice Sargent, because on one view, why is he going into loss, the type of loss? So if we pick it up at the bottom of page 49, 366, does the payment of a sum, so let's start at the beginning. On the foot then, clause 3 of the charter party fixes the damages for detention at £25 a day. Does the payment of a sum calculated on this basis, i.e. a payment for days used, form an agreed compensation for the loss which the owners have sustained in the circumstances of this case? I cannot think so. The loss inflicted on the owners and claimed by them is loss of another character, namely loss of freight, caused by the breach by the charters of their contract to load a full and complete cargo. And then he talks about primary obligations. The object of the second sentence of clause 3, the demurrage provision, is to provide compensation for a detention of the vessel in the course of fulfilling the primary obligation, not to give compensation for the breach of the primary obligation itself. No doubt the same delay in loading, which might give rise to a claim for detention, also resulted in a breach of the obligation to load a full cargo. But the breach of this latter obligation caused a definite separate loss, independent of and largely exceeding any loss arising from mere detention. And so in our submission, what Lord Justice Sargent is saying is that what matters here is that the loss is different.
Well, and he says that at the end of paragraph top of 367. It would unwarrantably widen the scope of the second sentence if it should also ascertain the damages arising from a breach of the primary obligation itself.
Yes. So what he's saying, therefore, is that you have to look at the type of loss.
Yes.
Because
I mean, at least the analysis stacks up.
Yes.
This
I leave Ryder Narcos well on the head on that basis.
Maybe we'll be doing the law a service if we at least explain or dispose of that case for the future.
Yes,
maybe we'll just be depriving future lawyers of a lot of funds.
Well, in one sense, my lord, one could do that, and no doubt the court will, with intellectual enjoyment, do so. But what one does need to ask, though, is what demurrage means.
Absolutely.
And this case is very helpful in explaining what it mops up, if I can put it that way. What it doesn't mop up are completely different losses. And different losses to what? Losses that are different from the loss of time and the loss of the profit-earning capacity of the ship. No other losses are caught within demurrage, which is why they have to ask themselves the question, what is the type of loss? Just as they had to ask themselves that question in Invicate and Bungie. And when we come on to Lord Justice Diplock in Swiss Atlantique, is why I think he brushes aside Ryder Narcos. It doesn't matter what the raciones decidendi was in that case, because the loss is the same as the loss which is covered by demurrage. That's it. It's the same type of loss.
Taking out of your course,
not at all.
Going back to where we were a while ago, I think you say, well, a ship owner shouldn't get more for something that will have been taken into account in arriving at the demurrage rate or the freight rate.
How do you mean more, my lord?
Well, he shouldn't have a claim beyond demurrage for a factor that will have been taken into account in fixing the demurrage rate.
Yes.
And it's on that basis you say, well, port dues, you don't get an extra claim because those would have been taken into account. Bottom fouling, that will have been taken into account, you don't get an extra claim. Will insurance costs have been taken into account in fixing demurrage?
Well, it depends. And again, I'm not a broker, so I don't know. But I mean, if one's looking at the fixed operating costs of the vessel and the loss of profit the vessel can be expected to make, then one would expect any of the fixed operating costs, which would include hull and machinery insurance and P&I insurance, to be part of that equation. Whether brokers actually break it down in that very neat way, rather than just look at what the freight rate is on the market.
But you'd expect the market to take into account insurance costs in some sense.
Well, the market may be in a position where it would like to take all the costs into account, but because the market's falling, there may only be enough just to cover the costs or not enough to cover the costs.
Well, the supply and demand curve should suggest that the sellers of the service should take into account their costs, which would include insurance.
Yes.
And I think Mr. Hancock was suggesting, well, the ship owner will incur insurance costs in insuring against some of these risks.
My lord, that doesn't help one in identifying what the concept of demurrage is.
Well, it might do if the unexpected event is taken into account by way of insurance, which is then reflected in a normal insurance cost, which is itself taken into account in fixing the demurrage rate.
My lord, in our submission, one has to go back to ask what are the parties, there are two questions. What are they putting together as a rate? And what is it meant to cover? And it may well be that in putting together the rate, I doubt any brokers are this sophisticated, but in putting together the rate, that's one thing, but what are they applying it for? Are they applying it to all loss? Or are they applying it only to what they're trying to estimate as best they can, which would be the loss falling on the owner if the ship has to sit there after the lay days? And our submission, just because the insurance may, I don't know whether it is or whether it isn't, may be an ingredient in the calculation of the demurrage rate, doesn't tell one, in our submission, just like port costs and things like that, doesn't tell one what it is intended to cover and whether the parties, by agreeing that rate, intend to mop up all loss. So far, one sees no support for demurrage having anything wider than losses due to detention, namely loss of freight and operating costs.
But running costs
Yeah.
must include insurance.
My Lord, I've said that, yes.
Yeah.
One would think
So my Lord's point does raise a question, really, as to whether there's any point in having extra claims if you're including all running costs, including the cost of insuring against extra claims.
My Lord, I think one risks getting over granular about what goes into a demurrage rate. I mean, one has no evidence about it. But what one sees is that it's meant to defray the cost to the owner and the loss of the owner's profit. I.e., I shouldn't have to bear these costs without having some money in for it.
Yeah.
And that's it. And it doesn't actually then tell one, oh, well, because one of my costs is insurance, therefore I'm not contemplating that it covers only the detention.
But you see, these cases are so rare because they're all covered by other clauses in the charter parties and the arrangements that deal with them. So this is a very unusual thing that slipped through the net. And as you said in answer to my Lord Justice Mayall's, bottom fouling is a given. It happens all the time. It's not something that's out with the usual, and that's why it would be covered. So there are no examples that we've been able to come up with of claims that, and when I raised the freak tornado, they said, oh, well, that's all dealt with by clause 26 or whatever it is in the standard form. So this gives us a hint that actually whatever words have been used, the concept is that it is every cost associated with the time value of the vessel that you're being compensated for, which includes the risk allocation for any other eventualities.
Well, then, my Lord, one would have to find some support for that somewhere, because then what is effectively happening is that the court would be deriving its own view of what parties are taking into account.
It's just commercial. It's just what happens in the world. And
intending. Well, my Lord, we have the history of demurrage. We have what demurrage plainly is seen to be. So far, I'm only at Ryder and Arcos, and I'm going to move on. But so far,
but there was no evidence. In this
no, but my Lord, there isn't any evidence in this case. But one has no indication in any of the authorities, till we get down to the bond, that demurrage is anything wider than simply making sure the owner isn't out of pocket. In terms of running costs, then is loss rate, and that's it.
Yeah. Anyway, you see the point that Lord Justice Newey made.
Yes, but in our submission, one has to keep those two separate questions apart. It may be included as an ingredient in the running costs, but is it intended, by being so included, to wipe out any recovery of any other loss, which is wholly different from operating costs and loss of freight?
Anyway, we can all agree that it would have been better if the Lords Justices sitting in Ryder and Arcos had spoken to one another.
I think I can go that far, my Lord, yes. My Lord, can I then take your Lordship to Chandris and his Branson Merler, which is in the first bundle of authorities at tab 8. 16 turn, please, in the report to page 74 of the bundle, page 254 of the report. The facts here were that a vessel loaded turpentine, which ended up being a dangerous cargo, and because she loaded turpentine, she was held longer at Liverpool during the war because she had to discharge into barges. And the argument by Mr. Mercator was that the demurrage clause wouldn't apply. And if I can ask you to turn on, as it were, as it is to page 74 of the bundle, 254 of the report. He refers to Ryder and Arcos. That case decided a point up to then left undetermined. Invocate, Steamship and Bungie had decided that damages for detention for breach of the obligation to provide a cargo were covered by the demurrage clause. But supposing that the breach of such an obligation gave rise to damages of a different character, not for detention at all, the demurrage clause could then not provide the measure. That's important. Ought the clause to be construed as exhaustive, so that no damages which could not be measured by it could be recovered at all, or ought it to be construed merely as applying to damages for detention, leaving damages of any other character to be assessed at large? The Court of Appeal in Ryder and Arcos decided the latter. He then refers to the facts, and then he says, this is a problem which might be dealt with in one of two ways. One way is to say that there's been a breach of contract causing dead freight as damage, and that dead freight is not excluded by the demurrage clause, which is not exhaustive. On that way of looking at it, the question whether the breach is of a primary or fundamental duty is irrelevant. The alternative way is to say that there's been a breach of the primary or fundamental obligation to load a full and complete cargo, and therefore that the demurrage clause does not apply. On that way of putting it, the nature of the damage, whether it was dead freight or demurrage, would be irrelevant. It seems to me plain that the Court of Appeal chose the former way of dealing with it, so the non-exhaustive demurrage clause. Lord Justice Banks thought it unnecessary to decide whether there was a breach of the obligation to load a full and complete cargo, and said that the loss was recoverable simply as damages for the breach of contract to load at the agreed date.
That's not quite right, is it?
It's not quite right, no, my lord. No. Lord Justice Atkin said 43, and then we have that the passage I've cited to you. Neither of these Lord Justices referred in terms to any primary or fundamental obligation. Mr. Justice Greer in the court below and Lord Justice Sargent did refer to a breach of a primary obligation, and it is on the latter judgment particularly that Mr. Mercator relies. And then, after the quotation from Lord Justice Sargent, neither Mr. Justice Greer nor Lord Justice Sargent in the passage that I have quoted disregarded the fact that the loss cause was dead freight, in other words, a different type of loss. Lord Justice Sargent particularly referred to it. If they'd been intending to decide the case on the ground that the demurrage clause did not apply to the breach of the primary obligation, it would clearly be necessary to distinguish invocate and explain the difference in the character of the obligations in the two cases. In my judgment, the ratio decidendi in Ryder and Arcos is to be found in the judgments of Lord Justices Banks and Atkin, and the reference by Lord Justice Sargent to a primary obligation is, strictly speaking, irrelevant. I think the point which I consider is in principle determined by invocate and is not touched by the reasoning in Ryder and Arcos. Now, in our submission, that is an important decision by a highly experienced commercial court judge, analysing the matter in the same way that I've analysed the judgment of Lord Justice Atkin, but in particular analysing it as dealing with whether demurrage is exhaustive or not exhaustive. And Lord Justice, Mr. Justice Devlin in Chandra's finds that Ryder and Arcos found that it was not exhaustive and plainly agrees with that decision. And the judges traced the history of Scotland and charter parties. I don't have time to go to the various editions, but if the court would look at the 13th edition, which is at tab 53, and the 14th edition at tab 54, the editors of Scotland endorsed, as it were, the analysis that Ryder and Arcos was a one breach case for Lord Justice Banks, a one breach case for Lord Justice Atkin, but a two breach case for Lord Justice Sargent. My Lord, that is the position as it comes down to the decision in Swiss Atlantique. I'll return to Mr. Justice Potter's decision in the bond in a moment, but it's convenient to pick up the fact that two other commercial court judges, Mr. Justice Webster in the Altus and Mr. Justice Evans in the Adelpha, also had the same reading of Ryder and Arcos and its effect. And although Mr. Justice Webster's decision in the Altus has been criticised, nevertheless his analysis was the same as that of Mr. Justice Devlin, namely that Lord Justice Atkin was finding one breach with demurrage not being exhaustive for that one breach. And Mr. Justice Evans in the Adelpha took very much the same approach, although admittedly overture. So
Mr. Justice Evans, I haven't been back to it. My recollection was rather, well, if I assume this, then that sort of thing. Did he actually really express a view?
I think he did, my lord. Page 314 in the bundle, the electronic bundle, tab 22.
And he says at the beginning of the sideline passage, in the left-hand column at the bottom, I'm prepared to assume that a damages claim may succeed.
Yes, my lord, but if he was against the damages claim, then he would have said that the damages claim is inconsistent with Ryder and Arcos. But what he does is he analyses the position in the same terms that Mr. Justice Webster did in the Altus and Mr. Justice Devlin did in Chandris. It goes on to refer specifically to Mr. Justice Devlin in Chandris and state that he doesn't see Swiss Atlantique as ruling out that position. And he's right to do that, because Swiss Atlantique doesn't rule out that position, as we'll see.
But it all rather seems to be, well, one view is this, rather than him coming off the fence.
Well, my lord, I don't think that's how it's been read, but I mean, at least he's saying that I don't think your case is unarguable.
No, certainly
because of Swiss Atlantique.
Yeah.
So, my lord, to Swiss Atlantique, and if I can take you first to the judgment of Mr. Justice McCatter, which is at tab 12.
I imagine you're conscious of the time.
I am very conscious of the time, my lord.
Yeah?
The court rises at 4:15.
4:15. I mean, at a push, I could do, say, 4:20, but 4:25.
Mr. Hancock slightly overrun. If I set myself to finish at about 4:05.
That would be fine.
So Swiss Atlantique, my lord, and Mr. Justice McCatter's judgment at tab 12. And the argument, this was an attempt to escape a demurrage clause. The loss claim was effectively the loss of the extra freights, which could have been squeezed in if the vessel had been quicker in her loading and discharging. On any view, as we see in the Court of Appeal, the claim plainly related to the loss of freight, which Mr. McCrindle, with considerable ingenuity, had to devise ways round of getting out. First of all, to come up with separate breaches, and then in oral argument in the House of Lords to rely upon fundamental breach, which caused the appeal to be adjourned. If we can pick it up at page 127 of the bundle, page 175 of the report. The fourth submission is different in character. This is in column 2, the third paragraph. It is based on the established breaches by the charterers of the laytime provisions in the charter. The loss of earnings under the voyages that would have been performed under this charter are special damages not covered by marriage. This submission depends upon a close analysis of the judgments in Ryder and Arcos, and especially that of Lord Banks. So the argument was that the type of loss is different. And what then happens is, if one goes over to page 128, top of page 176, and the top of column 1, Mr. Justice McCatter identifies what he sees as the reasons for the decision of the Court of Appeal in Ryder and Arcos. They can be concisely stated to be held recoverable by Lord Justice Banks as damages for failure to load in the agreed time, by Lord Justice Atkin as damages for failure to load a full and complete cargo in the agreed time, and by Lord Justice Sargent as damages for failure to load a full and complete cargo. So a completely separate breach, not connected with failure to load in the agreed time. The reasoning of Mr. Justice Greer had been similar to that of Lord Justice Sargent. So pausing there, Mr. Justice McCatter doesn't see, he sees Greer and Sargent, as it were, in one camp, and Atkin and Banks in the other. He then goes through the various passages in the judgments of the Court of Appeal, and if we can go on to page 129, we have Mr. Donaldson's argument that the loss was precisely the same as that covered by demurrage, and then at the bottom, Mr. McCatter says this, Mr. Justice McCatter says this: the competing arguments on this fourth submission advanced on behalf of the owners are nicely balanced, and I confess my mind has fluctuated in their consideration. Were it not for Ryder and Arcos, I would readily have accepted Mr. Donaldson's argument that the loss suffered by the owners here was indistinguishable in principle from that suffered by a ship owner under a single voyage charter when his ship is detained beyond the Hurley days. In consequence, I would have decided without much doubt that just as the consequential loss of future freight in such a case would be a loss by detention covered by the demurrage provisions, so should losses of freight under additional voyages that could have been performed under this charter be treated as covered by demurrage. And so again, he's looking at demurrage as covering the loss by detention and looking at whether this is a different type of loss or not in relation to a submission that the breach of the laytime provisions has led to a different loss. He then considers the connection between the loss of freights under the contract of affreightment and what the demurrage clause covers. And at the top of page 130, at page 178, he says this: in my judgment, the absence from this case of the special feature I have mentioned prevents the owners from being able to establish that their claim, either in substance or in form, is one other than for damages for detention. Accordingly, I do not think they can bring themselves within the reasoning of Lord Justice Banks and the general principle agreed by all members of the Court of Appeal must apply, namely that for a claim for detention by a ship owner due to the laytime provisions in a charter being exceeded, the demurrage provisions quantify the damages recoverable. So again, in our submission, making it clear that what the clause was seen as doing was quantifying the detention damages and no more, but any losses that are like the detention damages will also be, as I put it before, mopped up. And then in the Court of Appeal, Lord Justice Sellers, at page 136 in the bundle, page 538 in the report, the submission being made by Mr. McCrindle is summarised at the bottom of page 538 in column 1. The third proposition was that demurrage is not an exclusive remedy for a breach of the laytime provisions. It is so only where the claim is for what was described as mere detention. That proposition requires further consideration, which I will postpone until later. And then he comes on, after considering Ryder and Arcos. If you go on to page 137 and page 539, Lord Justice Sellers says this, second column, two-thirds of the way down. The dead freight claim, which the court allowed, was an additional and independent loss unrelated to the loss of use. The length of detention was not relevant to the loss from failure to load a full and complete cargo, which was loss of a different kind. If the vessel had sailed within her laytime, the claim for dead freight would still have succeeded. I do not find that Ryder and Arcos supports the argument which is advanced here, that there is some damage to be assessed on a separate ground or as a separate head by reason of the detention of the vessel. The figure of demurrage was the parties' agreed assessment of what was to be paid in the event of circumstances arising such as arose here. So a straight type of use, comparison of use issue. And again, another statement, which is the demurrage being the parties' agreed assessment of what is to be paid for the detention and nothing more. Lord Justice Diplock an Olympian attitude, felt he didn't really need to get into Rider and Arcos because it looked as though it was extempore. But if we pick it up at 138, at page 540 in the report, column 2, it was established in Rider and Arcos, first, that a charterer commits, which settled the controversies, the nature of lay days and demurrage, that's the wrong trainer point. First, that a charterer commits a breach of contract if he detains a vessel after lay days have expired. And secondly, that demurrage is liquidated damages for the detention involved. The nature of the damage which the parties have estimated the quantum in their agreed sum for demurrage is that during the period of detention, the vessel is unable to earn freight. And insofar as the complaint of the claimants here is that the vessel has been unable to earn freight, it is covered, in my view, by their own assessment of the damage to be payable, namely the daily demurrage rate. And in our submission, that is a very clear statement of what demurrage is and what it is liquidating. And it is very unlikely that Lord Diplock was saying anything different in Diaz. And then if I can ask you to go over to page 139, column 1, bottom paragraph, Lord Justice Banks, upon whose judgment Mr. McCrindle was based pretty nearly the whole of his argument, approached it from the other point of view. His approach was this: there is here one breach, a breach of the duty to complete the loading of the lay days, but two types of damages flow from it. One is that during the period of detention, when the vessel was unable to be used as a freight-earning instrument, and for that, the liquidated damages agreed in the form of demurrage should apply. But in addition, there is in the peculiar circumstance of this case, another head of damage, a head not related to the detention, a head not related to the fact that during the period of detention, the vessel could not earn freight. The second result of the breach was that when the vessel could earn freight, when the contractual voyage started, she had been damaged in her freight-earning potentialities because the total amount of cargo that she would carry was less than it would have been had the contract been fulfilled. It does not seem to me that the decision in Rider and Arcos, whichever of the rationales decidendi were to be accepted, helped the claimants in this case. What happened as a result of the undoubted breaches by the respondents here was that the vessel was detained, that during the period of detention she could not earn freight, she could not be used as a freight-earning instrument, and that is all. For that head of damage, the parties have agreed, perhaps wisely or unwisely, the figure that the defaulting charterers shall pay. And in our submission, that is an impeccable analysis, which actually means that the legal parlour game of working out what the ratios were in Rider and Arcos doesn't matter, because they were all one on this, that the concept of demurrage is that she can't be used as a freight-earning instrument, and for that head of damage, but no other, the parties have agreed their rate. And Lord Justice Harman, the previous page doesn't really say anything different from that. And the striking thing about Swiss Atlantique in the House of Lords was that the members of the House of Lords, effectively because they had the fundamental breach issue to grapple with, endorsed the reasoning of Mr. Justice McCatter and of the Court of Appeal. They certainly weren't saying anything different.
Striking thing about the Court of Appeal is it does appear to have been an extempore judgment, albeit overnight.
Yes, and then they asked for leave to appeal and got into another debate.
Yes.
They didn't get it from their lordships in the Court of Appeal.
No, an extemporary judgment from Lord Justice Sellers and Lord Justice Diplock. I mean, plainly, these two judgments are clear about that it's all about the type of loss, and that what demurrage is dealing with is detention, nothing else.
Yes.
So that brings me on then to the bond, and we say the bond is wrong for two reasons. First of all, the one found by the judge, which was that Mr. Justice Potter treated Swiss Atlantique in the House of Lords and the Court of Appeal as establishing that you must have a second breach and you must have a separate loss to escape from the laytime and demurrage provisions. And with the greatest respect to Mr. Justice Potter, that is simply impossible to discern from the judgments in Swiss Atlantique. The second reason we say he is wrong, although is that he misread Lord Justice Atkins' judgment as a 2-breach judgment when it was plainly a 1-breach judgment. And that the reading of it by Mr. Justice Devlin in Chandris and in Scrutton, and by Mr. Justice Webster in the Altus, is the better reading. Because what Mr. Justice Potter was forced to say is when he said breach, he really meant breaches. And in our submission, when one reads the whole passage in Lord Justice Atkins' judgment, where he talks of an obligation, the breach, curing the breach, damages for the breach, he is a single breach man. My Lord, the position post the bond and commercial certainty, well, in our submission the bond settled nothing. The textbooks continue to go their different ways. And indeed, the textbooks had to note that there was a body of learning the other way. So we have Mr. Justice Devlin in Chandris saying that Ryder and Argos was to be interpreted in one way, Mr. Justice Webster in the Altus agreeing with him, and Mr. Justice Bond disagreed with them both. But in our submission, that's fine. Had that been the Court of Appeal, then that would have resolved the matter. But it wasn't, and it didn't, as the commentaries show, because the point has rumbled on, and the matters, therefore, after the bond show no settled view. The judge was right to dismiss the argument to rely upon the Lux bar, because in the Lux bar the point wasn't argued. In the Lux bar, before Mr. Justice Langley, Mr. Bright QC simply argued that this is a very unusual demurrage clause, and therefore the bond doesn't apply to it. He didn't tackle the point head on. And to say, well, there are LMA awards which apply the bond, well, there are 2, and the judge very carefully analysed them. They appear to relate to one set of allied facts, with possibly the arbitrators being the same in both cases. And the judge sets that out in his judgment. And when one looks at the LMA awards, you see that it involves the same port, same time, and matters of that kind. So to say there's a body of arbitral learning out there, as I said, the point is now settled in our submission, is not correct. Reaction post the eternal bliss. Sometimes when a decision is announced, there is a gale of adverse comment or a gale of positive comment. The eternal bliss has not attained any adverse comment except from a very recent bulletin published by Michael Ashcroft QC on the 20Essex website. Mr. Ashcroft is one of the editors of Voyage Charter Parties, and Voyage Charter Parties is in the Bond School, not in the non-exhaustive remedy school, which Scrutton on Charter Parties is in. So that doesn't really help us. So this is not one of those cases where, whether the result is bad or not, the court, in Lord Mansfield's word, certainty and commercial certainty is more important than anything else. We will stick with the result whether it's bad or good. There hasn't been certainty, and therefore the court is in a position to approach it, as it were, de novo, and consider it once and for all, and to settle it. Lastly, in the few minutes that remain to me, I want to deal with the commercial arguments, which are addressed. The first is that what a very good thing liquidated damages clauses are, because they bring certainty. In our submission, that doesn't really assist the court. Of course they do. But, and a liquidated damages clause that deals with only losses for detention is just as certain, because it liquidates an important part of the everyday loss that will be suffered and deals with it. The parties agree a fixed rate down to the last minute that will be payable for that extra time. Secondly, the different type of loss inquiry and how difficult it might be to come up with different types of loss. And as I've said, that is an inquiry which has to come up under the existing law, under Invicip and Bungie. It came up in Swiss Atlantique. It came up in Chandris. It came up in Ryder and Argos. It may not have to come up very often, but when it does come up, the court is perfectly able to deal with it. And in looking at what the court was dealing with in Swiss Atlantique, for example, and the perimeters and parameters of the concept of detention or loss of use, loss of freight earning capacity, the Court of Appeal and Mr. Justice McAdder had slightly more difficulty. The Court of Appeal had no difficulty in saying this is obviously a freight earning claim, and it's obviously therefore caught by demurrage, which is the figure for the freight earning claim. then reliance is placed upon exceptions to demurrage and half demurrage. Well, we don't advocate any prorating of claims for damages. That's completely wrong analysis. The analysis is straightforward. If a liquidated damages clause liquidates the damages for a certain head of loss, then it does so. If there is an unliquidated head of loss, then that loss is recoverable in full, subject to the operation of any other exceptions. The problem which is posed as being, it's very difficult because it would be very odd if they were accepted from demurrage but ended up still being on the receiving end of a claim for substantial damages for something else. In our submission is highly artificial because the exceptions to demurrage usually cover strikes, storms, frost, that sort of thing. Almost all of those events are equally covered in the general exception clauses to be found in almost all standard forms of voyage charter party, of which I took you to clause 26 in this charter party, clause 11 in the GenCon form, clause 19 in the tank boy form. And then the time bar point, which is that, well, you lose your demurrage claim if you don't file your documents within a certain time. It would be odd, wouldn't it, in those circumstances, that you could still bring your unliquidated damages claim. Well, a number of points about that. First of all, not all time charter parties have a time regime like that. So what are the charter parties that don't? You're rather wagging the dog with the tail by looking at the special industry charter parties that do. Secondly, how likely is it that an owner who has been held up at a port due to breach of the laytime provisions doesn't put in his demurrage claim and doesn't also make a claim very shortly after that for the other losses, if he suffered them, as in this case? So, I mean, the idea that a claim is sort of held back deliberately to wait for 5 years and then springs out and the charter has destroyed all his documents in our submission doesn't really correspond with reality. If the owner has a claim, owners are not, in my experience and probably the experience of at least one member of the court, slow in bringing those claims forward.
Well, he may not know he has a claim because if it's a cargo claim, the receiver has a year to bring that,
Yes.
during which time the demurrage time bar may well have applied. On the other hand, if demurrage doesn't catch such a claim, the owner doesn't have a problem in the time bar for the demurrage.
Yes, Lord. I mean, it depends on what type of claim is made, but it would therefore be odd to try to unpack what the concept of demurrage is by the fact that if cargo claims are a separate type of loss, which they are, and the claim is one effectively as one for damage to breach of contract by way of an indemnity against the cargo claim they've had to bear, that may necessarily emerge later. So,
May or may not.
it may or may not, but one can't actually. Well, it may or may not. But one can't infer what the concept of demurrage is and what it's covering from matters of that kind. The judge was quite right to reject that as being a reason for, or of any relevance really, to unpacking what the concept of demurrage is. Unless I can help the court further, I hear 4 striking, but I'm operating by that clock, which is 3 minutes past 4. I end up, I think, having finished within my lay days.
There'll be no additional payment due then, Mr. Bailey.
I shall ask for my rebate, my lord.
Thank you. Mr. Hayward.
Hello. I will try to act with the utmost dispatch.
There'll be no additional payment due to you if you do.
Few points, my lord, but only a few points. Firstly, the bottom fouling example is, I would submit, actually a helpful and useful example. If it be accepted that bottom fouling is within the ambit of demurrage, and port dues are within the ambit of demurrage, then why is it not within the ambit of demurrage where a ship goes to a port which is known to have a reputation for the making of cargo claims against ships? As I said in opening, there are many ports around the world which have exactly that reputation. And accordingly, in agreeing to go to those ports, then the owners take upon themselves the risk of such eventualities. Secondly, my lord, to, in a sense, save time on this, invocate. I quite accept what my learned friend says in relation to invocate. Invocate was an authority which effectively says where your loss is detention, as in delay to the vessel causing loss of profit-earning capabilities, then it doesn't matter whether the breach that gives rise to that loss is a breach of the demurrage provisions or a breach of some other provisions. That is true, but it does not assist your lordships in relation to the question with which your lordships have to deal. The first case in which the question with which your lordships do have to deal arose was indeed Ryder and Arcos. And although we spent a lot of time debating the speeches in that case, which are not easy, what I would submit is the starting point is that the submissions made to the court were very clear. It was quite clear from the submissions made to the court that the case being put was that there were two separate breaches, and it was because there were two separate breaches giving rise to separate losses that the claim was put forward. Remember that the claim itself was solely for dead freight. There was no claim for demurrage, which had already been paid. So the only claim before the Court of Appeal was the dead freight claim. Next, my lords, in relation to the references to a single obligation in Lord Justice Atkin's speech, if your lordships read through that speech again, you will see that the single obligation to which reference is being made is the obligation to load a full and complete cargo. And that is clear from that portion of the speech which talks about the mitigation of the breach which has taken place at the expiry of the lay days by not having loaded a full and complete cargo as at that moment. In the in Reader and Arcos, then the difficulty, as I said earlier on, that arose is that by reason of the expiry of time and the coming into force of the winter marks regime, then the charterers simply could not mitigate the loss to owners because they couldn't load a full and complete cargo. Ergo, they remained in breach of the obligation as they had been at the moment that the lay days expired. In relation to Chandris, again, it's important that your lordships read the section of Chandris that Mr. Rainey took you to in its context. That section of Chandris was dealing with an argument based upon fundamental breach. And that was why it was talking in terms of primary obligations, because what was being argued was that an exceptions clause wasn't applicable to the relevant obligation on the same basis that came to be discredited in Swiss Atlantique. As far as the earlier editions of Scruton, perhaps again, if you can just look through the wording of those earlier editions of Scruton, I would submit that the wording is entirely ambiguous as between the two parties' cases before your lordships in the earlier editions. The two breaches analysis was taken up in the 1974 edition and remained in Scruton until 1996, at which point, when the editorship had changed, as I indicated, then the learned editors of Scruton were changed their position and indicated that the better view was that the two losses, one breach analysis was correct. But as I indicated earlier on, in so doing, in my submission, they base themselves on cases which are not reliable, namely the Adelpha, the Altus, and a reading of Reader and Arcos, which treated Lord same can wrongly treated them in that way. And then lastly, in relation to the reactions to the various cases, your lordships have a copy of the various different, rather limited responses that have been produced to the Eternal Bliss since the first instance decision was published. Those are in the papers that were sent to you. So for what it's worth, then you can see what the reaction of those people that have written on the subject is. And what I would say is that in comparison with that, if one looks for response to the bondee, which was unfavourable to the bond, what one sees is that there were no cases in which any complaint about the bond was put forward, and that's, as I said in opening, why this case, which is a very unusual case, is the first case in which the suggestion, which is now put forward and which was accepted by the learned judge, has been put forward. My lords, unless I can be of any further assistance, then those are my submissions in reply.
Thank you very much, Mr. Hayward. Well, we'll take time to consider our judgments. That won't surprise you. Thank you all, both to leading and junior counsel, and also to the solicitors for a very interesting day of argument. And when you get the judgments, please let us have typographical corrections, agree consequential orders as to costs, and anything else you want to disagree about will be dealt with in writing, and exchange submissions. But if you can't agree even that, we'll give directions on that basis. But thanks once again.
The normal 90-second